With us now is Jim Kistler. Jim is the president and CEO of the Associated Builders and Contractors, Heart of America chapter. Jim, thanks for coming in.
Good morning.
It's great to have you here. And this is a big topic, the EFCA, what the Workforce Fairness Institute refers to as the Employee Forced Choice Act. But the Free Choice Act, I guess, is maybe the...
I believe the official bill title is the Employee Free Choice Act, but
Okay.
forced choice is a more appropriate.
Let's talk a little bit about where this is. It has not been passed into law, but it's being put into law. It's, I guess, maybe accurate to say that Congress is still considering it, although it may not be actively under consideration now. But it's being, portions of it, I guess, are being put into effect by regulation.
That is correct. The original bill contained a number of provisions that would have worked adversely to the economy and to the construction industry, which was primarily where it was focused, but manufacturing and some other industries that are heavily unionized. And portions of that bill could not have passed Congress and will not pass Congress at the current time. However, administratively, the National Labor Relations Board is implementing some of this through rule and regulation.
Now, I know we don't want to drift away from the topic we're on here, but we seem to be seeing a lot of that lately, where in environmental matters and in some other issues, what can't get through Congress is actually put into effect by the rulemaking process.
Yes, and and that's forcing a lot of groups to go to court to challenge these. We've gone to court and challenged two parts most recently and successfully challenged them that were previously a part of the Employee Forced Choice Act. So if you cannot get it passed through the legitimate process, then you try to do an end run around Congress and implement it administratively, and that seems to be part of the Obama agenda.
So what are the parts of this bill that are objectionable?
Well, all of the Employee Free Choice Act was objectionable. Probably the most objectionable part, and we have not seen that implemented as yet, was binding arbitration. The original bill said if you couldn't agree within a 90 or 120-day span, the government would come in and tell you who you're going to do business with, which union you're going to purchase your labor from. And they would bind a company. They would just dictate that a company is going to enter into a contract. And never before in the history of the United States has the government told a private business, thou shalt contract with this person. So that part of it has not been implemented. But other parts of it where we're tightening the time frame for elections, currently elections occur in about 34 to 40 days, tightening those time frames, making it a much shorter time frame from the time union cards are presented to an actual union election being held, what we call ambush or quickie elections. That was attempted to be implemented. So there are parts of this that they're moving forward with. They're also trying to manipulate the unionization process, so smaller groups other than what were regularly recognized as collective bargaining units can unionize. And in some cases, they're even taking subsections of collective bargaining units and unionizing them and picking the people that they know will vote for the union rather than an entire department or company.
The micro union.
The micro unions, yes.
We need to come back to that, but let's go to the ambush election idea. The difference between 40 days and say 7 days or 10 days. And before we even touch on that, you mentioned that they attempted to do this. Was this one of the ones that was blocked in court?
Yes, it was. And this rule was passed in late last year. And at that time, there were a couple of recess appointments that were expiring. And so when they passed it, there were 3 sitting members of the National Labor Relations Board. Only 2 of them attended the meeting where this was passed. And this is a 5-member board. So for the board to actually take action, they must have a quorum, and a quorum would constitute 3 members in attendance. Only 2 members were in attendance when they passed this rule, and they tried to force it through anyway. And the court struck down that rule on procedural matters, saying you didn't have a quorum, therefore you can't do business. It was a procedural ruling. The court did not rule on the substantive issue, which we had challenged whether or not they had the authority to do this in the first place. But the court didn't rule on that. They threw it out on procedural grounds. So we're looking at possibly them trying to re-implement it later in the year, most likely after the November elections.
So that could very well come back, but for now it's dead. But you have to prepare for that anyway.
For now, it's been enjoined by the court. It is on hold unless a higher court overturns it, and we do expect it to be up on appeal.
Okay. So talk about what's wrong with having an election. Wouldn't it be more timely to get this thing decided more quickly?
Well, in most cases, yes. Unfortunately, businesses, and especially small businesses, often don't even know an organizing campaign is going on until suddenly a business agent walks in their office and presents them with signed cards requesting an election. This organizing campaign may have been going on for months up to a year prior to walking in your office and saying, here's cards, I want an election next week. And now, if you're a small business owner, how do you respond? You've got a week to try to talk to your employees to find out why they feel a union is appropriate and whether or not there are things that can be talked about between management and your employees to avert that. A week is just not enough time to address those issues, to do it legally, because it's very much like a court case. There are a lot of legal requirements that have to be met. For a small business owner to do that, they just don't have the time to do it. A much fairer time frame, which to give both sides the opportunity to present their case and to give employees an opportunity to educate themselves on whether or not they want to belong to a union. A week just isn't enough time. The current time frame, which is generally about a month or a little over a month, is a much fairer time frame for employees and for the employers.
And is there any downside to that? I mean, why would somebody object to taking time when to have that vote when you might have gone years and years and years and years before this without a union anyway, and so what's the rush?
The rush is that the unions over time have learned that the faster they can push a vote, the fewer votes they're going to lose once people educate themselves on the issues. Once people educate themselves on the issues, they begin to wonder whether or not that particular election is important to them. And I think for families to have to understand what they're getting and what they may not be getting if they vote for a union, it's a very important decision for families to make. And there are a lot of issues that play into this. Unions oftentimes promise things that they may not be able to deliver, and I can point to a study our group did on pensions. Many, in fact, maybe a majority, at least a plurality of the multi-employer unions, which are generally construction industry unions, have pensions that are severely underfunded. And that's been all over the news. So if you vote to unionize, suddenly you're paying into a pension that you may or may not see it come time for retirement, versus possibly not getting into a union and having a 401k where every dollar that's invested is yours from the moment it's invested. So there are a lot of issues that play into this. And if you have a particular union, say the St. Louis Carpenters coming in, who represent the carpenters in this area, and you look at their current financials of their pension, they owe $1.6 billion more in their pension than they currently have in money. And so I think employees need time to sort through the issues and say, what am I really getting? What am I not really getting? And that takes time.
And you were saying, too, that apparently employers, especially in small businesses, need to have a little more time so they can find out what's on the minds of their workers, why they're asking for a union election, and be able to respond to their concerns.
Absolutely. And employers want to respond to their concerns. Employees are an employer's most valuable asset. They cannot operate without that. And so they want to be able to respond to them, but they have to have the time to understand what the employees' needs are and to be able to address them. And to try to do that in a week is just simply not sufficient time.
Mm-hmm. Okay, so that's one issue. And let me just ask you about another related thing that I've heard about. I didn't see it in any of the literature here, and maybe it's a moot point at this point. But the card idea, where you don't have to have a secret ballot, you just do everything on the basis of who signs the cards. Is that something that is off the table now, or?
No, and there has been talk, and in fact, one of the National Labor Relations Board members, Craig Becker, who was a recess appointee that went off as of December of last year, had pushed very hard for the NLRB to implement card check. which would have avoided elections and not given employees the right to vote in secret on whether they wanted to unionize. So no, it's not off the table. There are a myriad of ways the government agencies can try to implement these types of things. So we're cautiously watching that. The board has not moved in that direction as of yet, but it is still a concern. And I think overall, if you look at the scheme of the regulations overall, what we're seeing is an attempt to interfere or inject them, the unions injecting themselves in between the employer and the employee and hindering that communication. And I think that's the biggest concern.
Another related issue in terms of the elections is a matter of privacy. I understand that there is some concern about unions having the ability to receive from the employer home addresses, telephone numbers of all workers so that they can go talk to the workers and their families about their worker rights and so forth. Talk about why this is objectionable.
Well, I think what we've seen in past campaigns is unions showing up at churches or catching you in the grocery store. I mean, if they have the ability to know all the intimate details of your life, number one, just having that exposure opens you up to identity theft. But you also have the ability of unions to inject themselves into your personal lives and into your weekends and whatever the situation may be. We believe in the privacy of an employee's information. The way the National Labor Relations Act is currently construed, organized labor has an opportunity to address those employees, and they can do it in a very organized and very structured manner, and they can present their case. Management can present their case. Management isn't going to go chasing you to the grocery store or the church or the local pub and try to convince you to sign a card. And that's the concern, is we want to respect an employee's privacy.
Is the idea that somebody from the union could show up on your doorstep and want to talk with you
and they do.
About this, does that open up the possibility of intimidation?
Absolutely, and we see it all the time. And the argument, it goes the other way. The unions try to claim that we intimidate, but when you see what goes on out there, we see cases where they take you out, and in cases on the East Coast, we've seen cases where the unions have taken them out and got them inebriated and got them to sign cards. The card part of that, the card check part of that is one aspect of it. But once you sign a card requesting an election, we feel it's appropriate to allow an employee a time to reflect on that decision and to make that decision in private. And if that union continues to hound the employee, it doesn't give them time to truly reflect on what's an important decision.
Is the privacy of employee records portion of this, is this something that is out there now, or is this something that's still pending?
It is still pending. It's out there and actively being pursued. What will happen this year in an election year is open to anyone's guess, and that's really the purpose for the Coalition to Protect Missouri Jobs. We want the candidates to understand the importance of these issues. We want to know as voters where they stand on these issues, and that's the whole purpose for the coalition that we put together.
More with Jim Kistler, including your calls just ahead.